When you separate from your partner, you need to separate your finances as well. In Australia, this is called a property settlement. It needs to be established if a property settlement is required. In most cases, if there's a long relationship, you have children, or you have shared property, this will be normally answered yes. There are some situations where it's not, but those are less common. There are 5 steps to a property settlement. 1. What is the value of the property pool? 2. What is a fair and reasonable percentage split of our property pool? 3. What assets and liabilities will we each receive to make up our percentage entitlement? 4. Making our agreement legally binding. And 5. Putting our property settlement into effect. Now, let's look at each step in more detail. Step 1. What is the value of the property pool? Before we can work out how the property is divided, we need to know the value of your overall property pool. There are some important things to note about this. First, everything is included in the property pool. It doesn't matter whose name it's in. Second, the values for each item of property are the values at the date they're being divided. That means if there's a gap of time between when you separate and when you do your property settlement, the values at the date of the property settlement are used. Third, it doesn't matter when an item of property was purchased or received. Everything is included, whether it's before the relationship or after separation. When we talk about property, we include everything with value, such as houses, superannuation, motor vehicles, businesses, shares, cryptocurrency, and collections of things like art or wine. We also include liabilities in the property pool. These are debts owed to third parties. They can include home loans, personal loans, overdraft facilities, vehicle leases, and amounts owing to the Australian Tax Office. If you had a credit card balance owing at the date you separated, this is usually included at that value rather than including spending after separation, but that can vary on the circumstances. To get to our final property pool to be divided, we add up all the property you own and deduct all the liabilities from those assets. Remembering that superannuation is included and everything is valued at the date it is being divided, not at the date of separation. Divorce Together uses software called a due to identify and value your property pool. After you give a due permission, much like the process when the bank does background checks when you apply for a home loan, it will prepare a balance sheet which will show you the draft property pool value. You can then decide if there are any other assets or liabilities that need to be included, or if you'd like to obtain any specialist valuations, for example, for real estate, businesses, or collections. We can introduce you to expert valuers if needed, and our mediator will walk you through each asset and liability to ensure that everything's been included and that you both agree with the values. This then gives us the value of the overall property pool. Step 2, what is a fair and reasonable split of our property pool? So this step is about how the property pool should be divided between you. Your property settlement entitlements are based on the principles set out in the Family Law Act. There's a myth that all property divisions have a starting point of 50-50. This is simply not the case. There's no standard or usual outcome or mathematical formula, as no two cases are the same. Instead, an assessment is made called the contributions-based assessment. This involves assessing the financial and non-financial contributions by or on behalf of each of you to the acquisition, conservation, or improvement of property. Financial contributions can include owning property before the relationship commenced, receiving an inheritance during or after separation, or family members loaning money or assisting to improve the value of property. Importantly, a person's contributions as a homemaker and parent are usually given as much weight as the main income earner's financial contributions from their salary or wages. At the end of this step, a percentage is assigned to each party's contributions to the property pool. Often in a long relationship, this will be considered equal, but not always. The contributions-based percentage can then be adjusted as a result of other factors that need to be considered. Not all factors will be relevant in every case. They include whether either of you has the care of children under 18 and what the parenting arrangements look like, each of your ages and state of health, each of your incomes, whether either of you have access to financial resources such as income from a family trust, each of your earning capacities, how the relationship has affected your earning potential. One example of this is where one of you has put your career on hold to care for your children and to support the other parent improving their career. Each of you having a reasonable standard of living, and if child support is being paid and how much. After weighing up all these factors, it may be that an adjustment to the contributions-based percentage is needed. The amount of the adjustment depends on the value of the overall property pool and what that means in real dollar terms. For example, in a $1 million property pool, a 10% adjustment would result in a $200,000 difference between what each of you receive. In a $400,000 property pool, that 10% adjustment would only be an $80,000 difference. So there's no hard and fast rule. Once we know the percentage division from step 2, the next step is to work out which pieces of the property pool you will each receive. It's not a case of selling everything and splitting the proceeds. If one person wants to keep the house, for example, if they can afford to buy the other party out, then there's no need to incur the costs of selling the house. We work out which assets and liabilities will be kept by each of you, and then there needs to be a balancing payment to achieve the percentage split, which might be from the sale of assets or one party borrowing against a property to pay out the other. Sometimes people agree to keep certain assets and liabilities jointly, such as a self-managed super fund or a business. Step 4 is making your agreement legally binding. We need to make sure that it's legally binding so that neither of you can make a claim against each other in the future. There are 2 ways to make your agreement legally binding. The first and usual way is to lodge an application for consent orders with the Federal Circuit and Family Court of Australia. The court will review your joint application and will make your orders if it believes the orders are fair and reasonable. The court can reject orders if they don't believe they are within a reasonable range of outcomes. The second way is via a binding financial agreement. This document must be prepared by a lawyer, and each of you must receive independent legal advice from solicitors for the agreement to be legally binding. Divorce Together's mediator will discuss the best way for you to document your property settlement when you reach this step. This will depend on what you agree to do in the settlement. For example, if you decide to retain some assets jointly, you'll probably need to do a binding financial agreement. And step 5 is putting your property settlement into effect. Once the orders are made by the court or your binding financial agreement is signed, then assets will be transferred or sold, superannuation split, and liabilities paid out. This step concludes your property settlement. Because you've used a consent order or a binding financial agreement, you won't have to pay stamp duty on the transfer of your house or car, provided the transfer happens after the agreement or orders are finalised. Let's work through an example property settlement. In our example, there is a family home with a mortgage, and each partner has a motor vehicle and superannuation. One of the cars has a higher purchase amount owing on it, and it's worth less than the loan payout figure. One partner has a credit card and an ATO debt, and there's a joint personal loan. After deducting the total liabilities of $2 million from the total assets of $3 million, the value of the property pool is $1 million. That is the dollar figure that needs to be split between each partner. In this example, the relationship was 20 years and there are 2 children under 18. Contributions are assessed as being equal, as there are no factors like initial contributions or inheritances. After considering the adjusting factors, Party B will receive an adjustment of 10% due to age, length of marriage, a lower earning income earning potential, special needs, and care of children. Party A does not have any adjusting factors. They earn a significant income and do not have the main care of children. Therefore, from the $1 million property pool, Party A will receive 40% and Party B will receive 60%. This results in Party A receiving property worth $400,000 and Party B $600,000. After a discussion, it was decided that the family home would be sold. The proceeds from the sale were used to pay out the home loan and the joint personal loans. Party A retained the liability of the credit card and the ATO debt. A super split was done, transferring some of Party A's superannuation to Party B, and each took a share of cash to balance out the property settlement to the agreed amounts. Thank you for taking the time to watch this video. We look forward to working with you.